Hi there and welcome to part 4 of my deep dive into the judge's summing up at the end of Miss Letby's original trial. Last time I got as far as mid-morning of July 5th when he finished off on child H. The remainder of the morning was spent reminding the jurors about the first 3 collapses of child I, with Sandie Bohin explaining away the significance to the collapses of the baby being seriously underweight on the basis that such low weight was no surprise with a child when feeding had not been possible on numerous occasions on account of illness. I'm not joking. I had to mention that one. But we'll not be going into the pseudoscience of their narratives of harm events too much. That stuff is all dead and buried by the work of the vastly more qualified world-class experts on Dr. Shu Lee's dream team after all. Just before lunch though, the judge made a point which does merit comment. I quote report. The judge reminds and stresses the jurors of their obligation not to research the case and not to discuss it among themselves before their deliberation. End report quote. Research can only mean educate themselves on the neonate health issues encountered in the indictment cases, using medical websites presumably. If he simply meant don't read newspapers, I think he would have said so. Why wouldn't a judge want jurors to be more knowledgeable on relevant medical matters beyond what they had been shown in court? Even more sinister is that prohibition on discussing the case even with other jurors before their formal deliberations. Might this be because those formal deliberations are to be firmly guided in a particular direction by a person or persons tasked with that function in advance of them? Why else might it be a problem for the same people who are going to be participating in those deliberations to get their brains going on relevant matters in advance? The foundational principle of the fairness which the presence of a jury imparts to a criminal trial is the bringing together of 12 different people, bringing 12 different life experiences, and 12 different sets of idiosyncrasies to bear on the question, not 11 sheep to be herded in a given direction by the foreman or whoever. Early in the afternoon session, Goss reminds jurors that on the file of a baby who does not feature on the indictment, Miss Letby had initially noted a time of 11 p.m. for an action, then changed it to midnight. This became an allegation of falsifying records in her trial. Miss Letby's entirely reasonable explanation was that the initial entry of 11 p.m. was an error and she had simply corrected it. As stated, that was on a medical file which is not a part of the case. Such error is an everyday occurrence in any fast-paced environment, let alone one where fragile young lives are on the line and a perfectly reasonable explanation is given. Moreover, being a file not on the indictment, this error was only noticed because of Miss Letby's honesty in actually making the correction. What might this judge be insinuating to jurors by including the fact that Miss Letby altered a record in his summing up when it doesn't even qualify as trial evidence? Contrast this with the judge's treatment of the information I gave in part 3 last week, that in cross-examination it was revealed that Jayaram had falsely recorded on child H's medical file that his chest drain device had been inserted in the correct 5th intercostal rib space, when in reality it was placed at the 4th. Which of the two errors should reasonably raise the larger question mark against the person's credibility? The one the person corrected of their own volition at the time, or the one which was kept secret by the person for 8 years and only came out because he couldn't deny it. James Goss would have us believe that he found the acknowledged and corrected error on a non-indictment case more damning to credibility than an error the perpetrator had kept secret on a case forming part of the trial. This is the only conclusion we can come to, because he does not remind jurors of Jayaram's documentary lie in his sham of a summing up. A further point of reflection in relation to Jayaram's false record is this. Clearly, he had forgotten about that lie 2 years later when conspiring with Breary and other consultants to bring the police in. Otherwise, he would have done the same as Miss Letby did and corrected the error, thereby avoiding the humiliation of having it later revealed in court. What does this oversight suggest? To me, it suggests that writing down what should have happened as opposed to what did happen is something he did so regularly that it was impossible to keep track of the occasions on which he had done so. That natural inference to a propensity to lie on Jayaram's part is perhaps the reason Goss thought it best not to remind jurors of the false recording of information which came out in court. Moving on, it was at the conclusion of his child eye summing up that the judge finally addressed the formal letter sent to the court by Lord Justice Jackson, warning that his recent experience of Evans as an expert witness had been that he was unprofessional, biased, unreliable, and his evidential contribution worthless. You will not be surprised to hear that Goss doesn't use any of those words, choosing instead to be abstract and neutral. I quote report. It was at that point, the judge says, Benjamin Myers case C for Letby's defense cross-examined Dr. Evans on a family court judgment report which criticized the medical expert, with strong views by Lord Justice Jackson. The defense said the inconsistencies in Dr. Evans' evidence undermined his case and the judge's criticisms were relevant. Or rather, the judge's criticism was relevant. End report quote. Note the way Goss evades responsibility for taking action on information that was provided to him formally by a fellow judge on a question central to the fairness or otherwise of the trial for the defendant before him. He makes it sound like some bureaucratic report which happens to include some quotes from Lord Justice Jackson rather than a letter penned by the other judge for the express purpose of warning him not to rely on evidence from Evans. That letter should have been fatal to the credibility of any evidence provided by Evans, especially in a large and complex murder trial involving huge amounts of technical information. Instead, in what amounts to a direction to his jurors to ignore the issues raised by the letter, Goss totally skates over what amounted to a direction to him from a more senior judge by saying the following. I quote report. The judge says it is up to the jury to consider the evidence and they know no more about the case and the judge's summary report than the agreed evidence which was presented to them. End report quote. What does that even mean? He is simply restating to the jurors their purpose in relation to evidence from Evans or any other witness. In taking that line, he is airbrushing out of existence the information received from an unimpeachable source that Evans is entirely untrustworthy and disreputable as a witness and therefore not to be relied upon. He does not rebut or otherwise challenge the informed assessment of Evans as an expert witness by his better qualified colleague. He simply fabricates a non-existent off-ramp, which he then invites his jurors to use in order to avoid addressing the relevance of what Lord Justice Jackson has said to their own assessment of Evans's credibility as a witness. By saying to jurors that they do not know the facts of that Lord Justice Jackson case, he is putting it to them that the lack of knowledge of the factual basis for the Lord Justice's criticism of Evans means it is okay to take an agnostic position on that criticism. He is quietly inviting them to demand proof as a condition of acceptance for what a senior judge has said of his direct experience of a witness. This is illegitimate for two reasons. First, the letter was not a communication to the jurors. That would be procedurally inappropriate and there is no mechanism to do it, but a communication to the person with dictatorial powers over the conduct of the trial, the judge. Secondly, it would be the height of impertinence for even a judge to effectively demand to look behind the words of a fellow judge by insisting on proof in that way. If it would be an impertinence for a judge to do it, how much more so for jurors who shouldn't even be assessing such communications in the first place? In a nutshell, what Lord Justice Jackson's letter said was this: "This man has badly failed me in the role he now purports to perform for you. In thus failing me, he has shown himself to be unqualified as a professional and unfit as a person. Using that man in your trial will be inconsistent with it being a fair trial." The summing up then moves on to Child J. As previously stated, I'm going to try to be disciplined and avoid medical matters, given that Professor Shu Lee's team have utterly demolished all pretensions by Evans and his team to credibility or professional competence in that area. I do want to mention, though, that this was apparently another case where the prosecution did not offer an attack method. I quote report. The prosecution said Letby did something or things to cause deliberate harm. End report quote. Before moving on, I just have to again remark that this was a neonate with a perforated bowel and not one but two stoma bags fitted. There is social media messaging evidence between nurses that such seriously compromised babies should not have been at a level 2 facility like the Countess, but at a level 3 one such as Arrow Park. Nonetheless, Sandie Bohin and John Gibbs still felt able to give evidence that two desaturation events were sudden. When would a health collapse be otherwise? And unexpected and without identifiable cause. And then the judge thought it appropriate to include these insanities or knowing lies in his summing up. In his summing up on Child K, the retrial conviction, the judge includes the mother's testimony that agreeing to end life support was the most heartbreaking decision of her life. Why did he find it necessary to remind the jurors to factor something which is of no evidential value in determining whether, as stated on the death certificate, the child died of respiratory distress syndrome and prematurity, or whether those inherent risks to life were exacerbated by attempts at deliberate harm days earlier? In reading of Goss asking jurors to factor the mother's emotion into their decision as to whether Miss Letby had made an attempt on the child's life, I was reminded of the grandstanding plea he made to the jurors on the first day of his summing up, June 15th, that they were to set emotion aside in their deliberations. Clearly, he only meant for them to set their emotions aside, provided they were willing to really live those of whichever parents whose emotions they were directed to instead. In many ways, the Child K case seems to have been something of a pet project for Goss, in that it is the count where he was most active in the use of the dark arts acquired over a lifetime of selective use of information and manipulation of facts to mislead. It is almost as if he, or person or persons behind him, had a point to prove with this one out of sheer vanity, or perhaps as a test case for future reference of just how far the British trial by jury system could be abused and perverted. Don't forget, this was also the undecided verdict chosen for the retrial and, against all odds, pushed through to conviction, arguably the most disgraceful of all 15. On an indictment which included no forensic evidence, physical evidence, or direct witness testimony against the defendant, it manages to be the weakest of the 22, lacking in coherence and consistency, not least in the telltale decision to not upgrade attempted murder to murder despite death occurring only 3 days after the alleged attempt on the baby's life, the charged, rather, attempt on the baby's life. There was really so little to it that they were not even able to spin the circumstances sufficiently to give the prosecution case the gloss of expert testimony. The general weakness makes it something of a snapshot both of the whole summing up and the overall case. I quote report. There were 2 further collapses and the prosecution alleged there was sabotage by Letby, but they were not the subject of charges. There is no expert opinion in Child K's case, and the evidence is circumstantial, the judge says. The prosecution urged the jury to rely on inferences. End quote. I draw your attention to the status of the 6:15 a.m. and 7:25 a.m. collapses. They were identical with the one at 3:50 a.m. which Miss Letby was charged with and eventually at the retrial convicted of, but are not on the indictment. Miss Letby was obviously documented as being elsewhere at the material times. Neither Jayaram or the registrar who was involved, Dr. Smith, made any mention of her in their witness testimony about those resuscitation events. Nonetheless, A. The prosecution assert that she caused those later collapses by sabotage. B. Openly petitioned the jurors to find her guilty on the charged count purely on the basis of perceived culpability in other cases. And C. The judge sanctions inferences, basically malice, as an acceptable alternative to evidence in this count by including in his summing up point B, which amounts to an open admission by the prosecution that it is engaged in an old-fashioned witch hunt and nothing more. To roll back in time in the summing up to the treatment of the charged collapse, Goss is at it straight away. I quote, "The court had heard it was possible for a user to pause the monitor alarm sounds for 1 minute." End quote. Nurse Williams had in fact given evidence that the 2016 monitors could be paused only after they began sounding. By artfully omitting to mention here in his summing up that the monitor has first to go off before being paused, Goss insinuates here to the jurors that Miss Letby had paused the monitor before attacking the child by interfering with the breathing tube. He had reminded them of the evidence of the main prosecution witness Jayaram in the same passage of speech. his walking into the room because he was concerned about Miss Letby being alone with the baby. Goss therefore stealthily and disingenuously reinforces Jayaram's evidence of the desaturation monitor not sounding by creating an inference which he knew to be inconsistent with the evidence that had been heard about the monitors, or the monitor. Last time, in part 3, I introduced my idea of Goss's novel sleight of hand in synthesizing evidence, more accurately suspicion, out of thin air via disinformation. Disinformation being the presenting of information which adds nothing to the description of an event, thing, or person, can do nothing to enhance understanding of that event, thing, or person, and is in fact redundant to the concept of that event, thing, or person, but because of the way the human mind works, will nonetheless introduce a calculated inference about that event, thing, or person in the instant set of circumstances. Without in any way wishing to patronize with information overkill here, disinformation is not the same as misinformation. Misinformation is the flat-out lie or misrepresentation of fact, if you prefer. A statement the person knows to be explicitly describing a state of affairs that never existed. Misinformation is the old-school brute force way to mislead, while disinformation is the stealthier, more sophisticated way to do so. Anyway, Goss is again synthesizing evidence and grounds for suspicion in the minds of jurors here. I quote, "In evidence, she said she had nothing to do with the events at 6:15 and 7:25. She agreed she had no reason to be in room 1 at 7:25 a.m. End quote. Let's start with the most obvious piece of disinformation, the second sentence. We know Miss Letby was not in room 1 at 7:25 a.m. That sentence, however, implies to the prejudiced, lazy-minded, or simply forgetful that she was in fact in room 1 at 7:25 for what was an identical collapse, including tube dislodgement, to the 3:50 one she was actually charged with. There is a pattern there for any juror in need of one in order to justify finding her guilty of the charged collapse. All that is necessary is for that juror to rely on Miss Letby's implied presence in what the judge says here, rather than the implication from absolutely no mention of Miss Letby in witness testimony about those two later collapses, that she was evidently not present. The fact that the implied presence is wholly fictitious is not your problem as a juror, as this information would have this is information which you, as a juror, have been given by the trial judge. Even if you'd had the wit to work out from the absence of Miss Letby, from the evidence of the two doctors who dealt with those two later collapses, that she was not a part of those events, this, especially as the judge has been silent on that aspect of the doctor's testimony, obviously trumps your own understanding of what took place at 6:15 and 7:25. This is reinforced by the judge's initial description of those collapses just 5 minutes before. I quote, "At 6:15 a.m. and 7:30, he's 5 minutes out, a.m., child K desaturated again, and it was noted the ET tube had dislodged again in the second event. Letby was on duty." End quote. Again, I remind you, this is the judge's summing up, not the prosecution seeking to persuade. Yet the attempt to create a pattern of behavior of tube dislodgement in the jurors' minds, which would only ever exist in those minds as actual events could not support it, is clear. Reference the first sentence from the previous distorted quote of Miss Letby's own testimony. In evidence, she said she had nothing to do with the events at 6:15 and 7:25. In speaking about the charged collapse just 10 minutes earlier, Goss included no mention of a denial of deliberate harm by Miss Letby. To already suspicious minds on the jury, therefore, the words Goss now puts in Miss Letby's mouth here in relation to the later collapses is a tacit acknowledgement that she had something to do with the earlier charged collapse. There is no reason to include reference to these later collapses, which do not form part of the case, except to set up this inference for the lazy-minded or already prejudiced. Anyway, that brings us up to child L, the twins rather, child L and child M in the summing up. I will pick up from there in the fifth and final part of this deep dive into his summing up. Feel free to share your thoughts and any information you think might be of interest to myself or anyone else in the comments section. As usual, thank you for watching, thank you for your time, and all the best.